Yes, sorry for that. I think I was assuming that Instagram's this 1 hour limit has been ended, but it is there. So that session has been uploaded. So we'll start the second slot now.
All right, just clarify this one thing. Is my voice better now? Is it audible?
Yes, sir, it is audible.
Everyone, is it fine, or should I again remove it?
If anyone could just respond in the comment section so we could know if it is clearly audible to you. Yeah, sir,
All
I
right,
think it's fine.
correct. So, and see what a coincidence that on the aspect of bail, it's a new video because this topic is actually big, and it will be better if people take it, watch it as a very separate video. So, chalo, let's शुरू कर देते हैं फिर. So what I was saying is section 45 is the one which deals with the provision of bail under the Act. Now, section 45 is such a draconian provision that it, in the garb of being a provision for anyone who has been arrested to be able to secure bail, it does actually opposite of what it says. The provision makes sure that if you have been arrested, then you will not be enlarged on bail. And I'll tell you why it is. If you read the section, and once again, I'm not going to verbatim read it. I'll try to explain it in a very simpler form. It says that if somebody has been arrested, has been brought before a court, now that court will have to first give an opportunity to the public prosecutor, a first notice and opportunity. Fair enough, that is there. And after hearing of the prosecution, only and only if the court says or thinks that the accused person has not committed the offense, number one. Number two, while on bail, he will not commit any other offense. Only in those two conditions that he will be enlarged on bail. So what the provision says is, first of all, there has to be court satisfaction that the person who has been arrested has not actually reasonably committed the offense. Number two, he will not commit any other offense while he is enlarged on bail. Now, my point is, how is that even possible? Because during bail, not everything is there before the court. The only thing which is there before the court is the authorities' reasons for the arrest, which they have to show to the court, but they don't even give it to the accused person. And given the small amount of data that is there, can the court reasonably say, okay, fine, I find a conclusion that you have not committed this offense. Reasonably, I have this belief, or maybe prima facie, I have this belief, and I have also prima facie belief that if I, release you on bail, you will not commit any other offense. That's not humanly possible because no one can take guarantee as to what the person will do once he's out on bail. We don't know. At second time, the very first condition that the court has to reasonably come to a conclusion that the person is innocent, he has not committed an offense, will that not amount to discharging the person right there? I mean, is that the purpose of bail, or for that, or is that the purpose of framing of charge? One, when one is seeking bail, it is simply because, and the basic jurisprudence of bail is also, the court has to see कि भैया what exactly is there that the authorities want from the person who has been arrested. It is very simple to understand that if you arrest someone, then you arrest that person for some specific purpose. Maybe you want some information from that person. Maybe you want that person, you want to, ask certain questions to that person which he might not answer. You want that person to not evade. You want to confront that person with certain documents with some other person. I don't know, it could be many. But that purpose can be achieved in 5 days, 10 days, 15 days, 20 days, maybe 1 month. But you cannot keep someone incarcerated for the rest of their life or for the rest of their trial. But this act has made sure, this law has made sure that once someone has been arrested, then he must suffer, he must stay behind the bars till the end of trial, and even after end of trial, because the conviction is, in my opinion, practically guaranteed. So what exactly are you going to do? You're going to live your life behind the bars, because the court cannot ask the authorities कि भैया तुम्हें चाहिए क्या इस बंदे से? अगर तुम्हें कुछ नहीं चाहिए, तुम्हें जो भी तुम्हारी इंफॉर्मेशन ठीक से मिल गई है, then why are you still keeping him in custody? Because if he'll be able to furnish the bail, then we'll release him, and he'll when he furnish the bail, he will be available for the trial. There's no point of incarcerating him behind the bar. But can the court ask this? The court cannot ask this, because court is bound or is obliged to look at these two principles. Ki, bhaiya, whether I think reasonably he is not committed the offense. Number two, whether he will not commit any offense if I let him out on the bail. Now, as a judge, as a court, how can I say that I reasonably believe that he has not committed the offense? By doing so, I'm actually saying that this person should not be arrested. This person should not even be investigated. This person should be discharged then and there. But that's not the case. And therefore, this section is actually in violation of not just basic principles of criminal jurisprudence or the bail jurisprudence. It is also in violation of Article 14 and 21 of Constitution. In short, it is also in violation of Part 3, our fundamental rights of Constitution. These provisions were actually challenged in an earlier judgment of the court, where Nikesh Tarajan Shah's judgment. In that judgment, the Supreme Court categorically struck down these two conditions by saying that these judgments by these provisions are actually in violation of fundamental rights of jurisprudence under Constitution, and therefore they should be struck down. So these two provisions are gone. But this time, when this point was raised again before the court, that these provisions are actually in violation, and there is also a verdict from this court only, please consider it. The court said, look, earlier, when these provisions were struck down, there was some defect in the law which actually made it to conflict with the fundamental right. And what that defect was, earlier the section said if somebody is charged with an offense, scheduled offense, which is punishable more than 3 years, only then these conditions will come into the picture, and it was nothing to do with the offense of money laundering. However, now it is like, even if you are accused of any offense which is punishable for maybe 1 year, for 6 months, for 2 years, but it is a scheduled offense, and you have been an accused under the PMLA Act, now you will not be given bail unless those conditions are satisfied, because this 3-year rule has been taken out, has gone. Therefore, these conditions will now not stand in conflict with fundamental rights, but they are completely constitutional and reasonable. Plus, the court said, when another point was made by the private parties, that these special courts that you have made under the PMLA, they are presided by officers who are at the rank of ASJ or SG. That means additional session judges and session judges. That means they have been given power, they have the power to use under section 439 of CRPC. And this section runs foul of that section as well. The court said that, look, these courts, even though they have been presided by session judges and ASJs, yet they are not equivalent to ASJs, but they are akin to a magisterial court. And this was something very hard for me to digest, and the reason the court gave it, because the process of committal has taken away from this act. In CRPC, what happens is, if there is an investigation about commission of offense and the offense is session triable, then once the charge sheet is filed, the offense gets committed to the session court, and that's when the session court starts the trial. However, in this case, there is no need for committal, and it is given in the act that there is no need of committal. Whenever the complaint is filed before the special court, the court can directly start with the trial. So the committal process is not there, and it is lack of that process that makes it that the special courts are akin to magisterial courts, and therefore they have to follow the procedure under section 437 of CRPC, not the 439, and therefore they are in consonance with section 45. However, I once again differ from that, because even under section 437, there is actually no such conditions, there is no twin condition like we have in section 45. But according to me, this definition that the court gave, that simply because the committal process is not there, therefore these courts are akin to a magisterial court, I don't agree with that, and with all due respect, I personally don't agree with that, and I have my reasons for that. My reasons are very simple, that when somebody gets arrested, he gets produced before a magisterial court. Why? Why is he not? There is no provision that he will be produced before the special court. However, under the PC Act, the somewhat similar legislation, whenever somebody gets arrested, he gets produced before the special court and not the magistrate. In that court, in that act, Prevention of Corruption Act, it is very specifically mentioned that for specific purposes, the session under 153, you will have to move directly to the court, not before the court of magistrate. However, in this situation, again, this provision is also missing. So let's say, Priya, if somebody has, let's say, committed a scheduled offense, they have committed a lot of wealth, that they have accumulated a lot of wealth, and for some reason, and let's say they have been convicted of scheduled offense, that means it's a lot more stronger case for the ED to investigate, and the ED does not investigate for whatever reason they choose. But you know it, and if you have to file a complaint, where will you go? Can you go directly to ED? Maybe, maybe not. But what after that? Because they are not investigating it. If they would have wanted, they would have investigated it earlier. They are not doing it. So where will you go? Will you go to the special court? No, there is no provision for that. You will have to move to magistrate only. If you want to file an application under 153, you will have to go to magistrate only. You cannot go to special court because those provisions are mentioned. So these things, first of all, the first remand, then the filing of these applications, the absence of this provision like we have in PC Act, all of this, because of all of these, I feel that the special court are actually akin to a sessions court. Especially they are also presided by ASJL and not akin to ministerial court. And therefore, the provision of bail should be in consonance with section 439 of CRPC and not like these twin conditions that we have, because these twin conditions have actually no reasonable nexus to be to with the act, the objective of the act that they are trying to achieve. On one hand, you say that this offense is so wrong, it's so heinous that it affects the national security and everything of the state. But at the same time, at the same breath, when you see the offense, the punishment for the offense, if somebody gets convicted, it is only for 7 years max. Whereas if somebody commits rape, somebody commits murder, somebody is charged with maybe POXO or maybe some other heinous offense, maybe UAPA, not UAPA, there's a twin conditions there, but some other heinous offense, he wants bail, he will not have to go through these two conditions. He'll only be judged by the provisions given under section 437 and 439 of CRPC. That's it. Now, this logic the court gave, I just disagree from that. And another thing that court said, look, it is because these courts are akin to ministerial courts. Why these courts are akin to ministerial courts? Because they have the power to give bail at the very moment when somebody is brought before them. But the point is, you don't bring anyone before them. It is only when the detention has already been authorized that you bring somebody before the court. After this was okay. I've already discussed this ECR thing. I'm sorry. Just the one thing that I actually wanted to add in the end, which was not these concepts that I have actually spoken about as of now are the major concepts, and I've tried to give it, step by step understanding as to what happens, then what happens, then what happens, and then what is going to happen now with the judgment. The one thing which is not there in the act, in this judgment, but perhaps I feel I should tell you, the section 63. If you remember, we discussed about it. It is about the punishment if you don't, or if you don't oblige to, if you don't give the correct answer in the section 50 when you get a summon, you will be punished under section 63. And I said section 50 only deals with, when you call somebody like a CA, CS, maybe an advocate or someone to bring forward the records of their clients because they have a suspicion that their client might be involved in the money laundering. I feel even that section is unconstitutional because that section directly hits at the root of professional privilege communication. If a client walks through my doors, the office of my doors, tells me something about it, am I liable to disclose that to anyone? No, that's professional privilege. If somebody walks into the office of a CA, will the CA be can the CA be compelled to give the answer or to give those details? All of these things also hits at the root of this act, which according to me is to this day when I wrote the paper, I actually said that time, and I'm still saying, and I say this time and again that it's a completely flawed legislation. This act needs to be, this act needs to be not amended, but changed completely if this menace of money laundering is to be curtailed or to be checked. But yeah, I guess I'm just done with this judgment because that's all I could have get from the judgment. Is there any, does anyone have any question?
Yes, right. You can type your questions in the comment section below. And so that was quite an extensive analysis. And I don't think on the plain reading of the act, we would get an understanding of the level that you have said. And you have like related it with the judgment really well. So if anyone has any questions on the Money Laundering Act and the recent judgment that has been passed or whatever sir has explained, so you can type your questions in the comment section.
But I guess then we can wind up the session.
Yeah, I think there are no questions.
I hope
So thank
you
you
have
sir for
enjoyed.
joining. Thank you everyone for joining. And the session, part one of the session has already been uploaded on our Instagram channel and it will be uploaded on YouTube in due time. And this session will also be uploaded. So thank you guys. Have a good day. Thank you, sir.
All right, thank you, sir.